Now, welcome to today's episode of Beyond the Gavel. Here we're going to welcome a lawyer whose career has been shaped by a much lived experience as well as by legal training. Donn Christensen is a seasoned plaintiff trial attorney with more than 2 decades of legislation behind him, spanning personal injury, civil rights, government tort, medical malpractice, and complex catastrophic claims. He works at countrywide trial lawyers in California and has earned a reputation for meticulous case presentation, compelling advocacy, and we're going to see how that developed over his journey, and a genuine commitment to the clients he served. What distinguishes him is that journey that brought him to the plaintiff bar. A wrongful arrest in 1989, followed by years observing stark disparities in the justice system, shifted his path from broadcasting into law. That personal history informs the empathy, the urgency, and the moral clarity that underpins his practice, because he has represented communities often overlooked, and he brings an understanding of hardship born of his own early warning experience, just the same as myself, where we have worked our way up through manual jobs in the service industry or navigating the realities faced by those who rarely see their stories heard in court. So in our conversation, we're going to explore the evolution of plaintiff practice in a digital age, the craft of listening and of storytelling, and how important that is in a court, the challenges of managing expectations with honesty, and the responsibility lawyers carry when they stand between an individual and institutional power. For clinicians and lawyers, and anyone with an interest in how real cases unfold beyond the paperwork, Donn offers a personal perspective rooted in humanity as much as his legal skills. So, Donn, thank you so much for joining us today on Beyond the Gavel.
Well, thank you, Dr. Peyton. It's a pleasure to be here with you today.
I'm just so blessed that you came, and with our previous conversations, I know a lot of stuff or similarities in our background as we worked our way through. Tell us a little bit about how you got to where your early stage and how you got into the legal profession.
Well, it was very circuitous. It was never the plan for me to be an attorney, or much less a trial lawyer and a plaintiff's lawyer. I was not a very diligent student in high school and was growing up here in 1980s Los Angeles as a teenager, spent most of my time and money pursuing music and going to shows downtown and seeing that the punk bands were very vital. And I was a big part of that. And I wanted to be in music more than anything. So I went to broadcasting school. I left home at 18, got a job, put myself through broadcasting school, and I was working in radio because I really enjoyed music. I had no degrees other than my high school diploma. And in my 8th year of broadcasting, I was working up in Ventura County, California, and I had an accident where I was knocked unconscious. And a police officer arrived after paramedics and a medical doctor at the scene, and they told him I was unconscious behind the wheel. And he ordered me out of the car while I was unconscious. And naturally, I didn't get out of the car. And he had been issued a stun gun that week. It was a 50,000 volt taser. And he used it on me 10 times to pull me out of the vehicle. And then the first thing I remembered was I was in a lot of pain, and I pulled myself free from his grasp. I'm a bigger person than he was, and that embarrassed him in front of the witnesses, I guess. And he threw me to the ground and handcuffed me and took me to the jail ward of the local hospital. At which point I was shackled to a gurney, and a patrol sergeant came in and said, "You look like a smart kid," because he knew something had gone wrong and that this shouldn't have happened. He goes, "But if you look like a smart kid and if you know what's best for you, you'll forget about this whole incident. And if you promise me you'll do that, I'll bring your car out of impound and we'll drop it off at the house for you. And you should keep in mind, we do know where you live." And I was smart enough at least to take the hint. And I nodded and said, "Yes, sir, absolutely. There's no reason this needs to go any further than you and I." And they unshackled me and threw me in the back of another police car and dropped me off at my home. And 40 minutes later, my car arrived. And 20 minutes after that, I called a reporter from the local paper and told them what had happened. And the next day I was front page news, and lawyers began calling me. And I didn't know at the time exactly how illegal and wrong that was to reach out to a victim of anything, much less whether it's a police misconduct or a motor vehicle accident. It's illegal most everywhere, as far as I know. And I knew that wasn't the lawyer I wanted. And I contacted family, and I was connected to some very good lawyers in Los Angeles who represented me in a civil rights action. And during that process, I became aware of other victims of the same police officer. I met the family of a young man who had also been arrested and shackled to a gurney. And when the officer used the taser on this young man, young black man, he had a heart condition, which the officer was unaware of, but the taser actually caused him to have a fatal heart attack. And I met another young victim who was from the Oxnard area, the Five Points area of Oxnard, and he was Latino, and the officer restrained him and then kicked him in the face and blinded him in an eye. And there wasn't a lawyer who would take their cases because they were concerned that the juries would take the words of the police officer over these clearly wronged people. And the only reason my case got taken was I was a young white man with no criminal history. And the injustice done to me was no better or worse than the injustice done to these other people, but my race played a huge role in me getting justice.
So how has that continued to influence your approach in representing clients, especially in cases involving civil rights and institutional power? How has that influenced you there?
Well, I think that's when I realized there was an opportunity for me to do more with my ability to speak and present things. I mean, as a radio broadcaster, it's fabulous training for trial law. You're actually persuading people to visit stores or come to promotions or go to clubs or attend concerts or buy a product or listen to a song or find another way to entertain them. And so you're persuading people with just your voice. And so you learn to convey messages and emotions to people in a way that's real. So I think that's an important part of being a trial lawyer is you have to be a storyteller. But my experience with the police put that fire in my belly to take all of those abilities and channel them into helping people who weren't getting the assistance I got. I took my settlement money, went back to school, left the broadcasting industry, had to go to junior college because I had no GPA as a result of my high school negligence, and start from the very bottom. But I earned my degree, went to USC, got a philosophy of ethics degree, and went to USC Law School and got a Juris Doctorate there. And I pursued the Post-Conviction Justice Project at USC, where I represented wrongfully convicted people, and then police misconduct cases throughout my career because I had a passion for it. I know personally that there are people who have been wronged, many of them, and many of them never get their day in court and don't get justice. And I wanted to, at least in some small way, take the advantages conferred on me by that settlement that I obtained and then put it back into the community and help people get their day.
Well,
And
isn't that so important? There's two things you're pointing out there. Is one is your ability. You had the ability to do a law degree. You had the brain. What was missing was the passion.
yeah,
And a lot of people end up in law or medicine because they do, because of family, because of whatever, and they don't have the passion. And you see a lot of that coming out. Oh, I'm 9 to 5, or they don't have the passion to finish what you start. You
yeah,
rest after it's done. You don't say 5 o'clock rest time. You do what
right.
has to be.
Yeah.
And you have really demonstrated that. And I'd like to explore a little bit further. You were talking about your experience. I mean, you and I played guitar and all that sort of stuff, but there's something you brought up about storytelling.
Yeah.
Tell me about storytelling and the importance of that, not only to opposing lawyers, but also in court and to a jury. Tell me about the importance of your learning as a broadcaster in your storytelling in court. How does that work out?
Well, I think there's multiple levels to that. I think, initially when I first started in broadcasting, I had been inspired by DJs I had grown up listening to that I found entertaining. And at first I was emulating their style. And I was trying to tell things the way I thought they would tell things. And about 3 or 4 years into my experience, I ran into a fabulous program director at one of the better stations I worked at, and he took me aside one day. He goes, "You know, Don, you could be very good at this, but you got to stop being whoever it is you're trying to be and be yourself." He goes, "When you're off the air and you're genuinely you, you're a very funny, entertaining person. But on the air, you sound and act like someone else, and try to get in touch with who you are and be genuine and authentic and try to tell the story from your own perspective without actually bringing in these other mannerisms." And I think a big part of it was I spent that 7 or 8 years learning who I was and learning to convey that and be myself. And I think that's one of the things I always tell young lawyers: don't copy other good lawyers. What they do works because it's what they do and it's who they are. Find out who you are. I know some lawyers who are very dramatic in court and they're very successful with it, but if that's not who you are personally, when you try it, it's going to come off as inauthentic. And juries, like all people, I mean, if you've done anything with sales or retail work, or even I worked in a gas station in high school. It's about dealing with people and being straightforward and genuinely interested in what they have to say and presenting things to them in a way that makes sense to them rather than in a way that tries to impress. Like so many lawyers in court will speak in legalese during trial. Well, we've got lay people in the jury. They don't know the difference between per se and res ipsa loquitur or any other Latin phrase you want to throw into a case. It's just confusing. And it sounds like you're trying to talk over their heads. It's insulting, really. And so storytelling, I think, is the art of making a story not only interesting, but also understandable and compelling. And you have to sort of pay attention to the people you're telling the story to. And I think that's always been a part of my life growing up in broadcasting as a young man. I learned to know who my audience was. Demographics are a big thing.
Yeah.
And jury selection is very much the same. And it's even easier in jury trial because you don't have this sort of vague statistical understanding of who most of your audience is and where they're living and what kind of jobs they have. You actually meet them. And you have an opportunity to speak with them before trial begins, and you interview them, and you can pick up factors. You find out what they do for a living, if they're married or not, whether they have children, whether they have relatives in law enforcement or legal practice or working in the courts. And as you assimilate all of that information, you can understand sort of how they may see things. And then you try to persuade them by telling them the story that reaches them. You can't tell the story. I can't tell the story about civil justice cases or police misconduct cases from my own perspective. I'm angry about misconduct, but most of my juries aren't. They don't have that same background and experience. So I have to talk to them about ways to see what happened from the police officer's perspective. And you bring in a police expert who talks about how it should have been handled. And you talk about the rules and you explain to them, hey, look, if people don't follow the rules, even if they're police officers, they should be held accountable for the rules they've broken. And this is a story about misconduct, somebody who did their job the wrong way. They know going in that they're going to be dealing with rough elements of society or that they're going to be dealing in situations that are dangerous. That doesn't give them the authority or the right to brutally assault people. And that's what happened in this case. And it's
Yeah.
important that we hold them accountable too,
So
because
you're
law and
coming
order is, yeah,
persuasion, and part of persuasion, which is sales, but it's persuasion. I'm not going to say as a surgeon I sell anybody anything. I have to persuade. It's the same damn thing. But the point is, you're going behind. In order to persuade anybody, you've got to come from where they are. And
right.
even in you've got a lot more jury trials, for instance, than we would have. We have a lot more where judges are sitting alone. And again, it's a good lawyer knows the law. An excellent lawyer knows the judge. You've got
Sure.
to go on the wavelength of the people who are making the decisions.
Sure.
And, facts tell, but stories sell. They're
Mhm.
parables. And a parable that includes what you want to show going on. And I think you, par excellence, have started to use that in the court environment. And that's what makes you so tremendously successful.
Well, it's been very helpful. And honestly, most lawyers are very boring in their presentations, and juries will fall asleep on you.
Yeah.
And I think if you keep it interesting and you speak You speak to people directly without trying to make it sound like it's more than it is. I'll give you one example. I had a medical malpractice case. It was after a stomach surgery, there was a frozen bowel and it went undetected. And they discharged her despite complaints. And she ended up needing a G tube permanently as a result of missing the frozen bowel. And their whole defense was that in one of the medical notes, a nurse had indicated she thought she heard bowel noises. But that was the only evidence they could find that the bowel had been working post-surgery. And the medical expert for the defense kept calling it crepitus. Crepitus. Well, crepitus is a very fancy word for bowel noises. And during his deposition,
completely out of context.
yeah, but nevertheless, that was their defense. It hinged entirely on this single note. And so at his deposition, I allowed him to call it crepitus and went along with it. I had seen his report when they gave me the expert materials in his files. And so we went through the whole process. And at trial, I stopped him. And when it was my turn to examine him, I said, "Doctor, isn't it true that crepitus is just bowel noises? You keep saying crepitus, it's bowel noises. Isn't that true?" And he said, "Yes." So I said, "Is a fart crepitus, doctor?" Well, he goes, "Well," and I'm like, "Yeah, technically, sure." I said, "So your whole defense is that the nurse may have heard a fart?" And he was upset, of course, but the jury laughed. And so I called it the fart defense throughout. And of course, they lost, and they were very upset about it. But it was a ridiculous and absurd defense to begin with, and they totally deserved it.
Totally.
And they just never regained any credibility with the jury because they sat there talking about crepitus for a day and a half. And when it was my turn, it turned out they were talking about farts. And so they looked ridiculous. And so the story changed entirely. I had a seriously injured client who shouldn't have been in the situation she was in. And they tried to defend and took it to a jury on crepitus, which is absurd. And I kept telling them it was absurd. And they, of course, didn't want to listen. Medical malpractice cases in the States can be very difficult. The burden of proof is very high. And you need to have medical experts, and they're very expensive. And then we're also in California limited in the amount of damages and the fees we can take. So very few people take them. So on top of being difficult, complicated, and expensive, the compensation is very low. And that's recently changed, and they've made cost of living adjustments. But we had restrictions imposed in the 70s that didn't change for 35 years. So with the cost of living adjustment being absent, the fees awarded were smaller and smaller, and fewer people were actually getting the court representation they needed in cases that deserved it. Now, obviously, there's a lot of error in any practice, whether it's legal practice or accounting or medical practice. Not all of it is negligence. In fact, most of it's not. Most of it's simply an error, and it's correctable.
So how do you decide up front whether you're going to take something? I mean, somebody walks in the door, we all know the majority are complaints and not negligence, the vast majority. So how do you make that initial determination as to whether you're going to put all that time and all that effort into this? What guides you?
Generally, I mean, I would say the biggest difference, it's changed over the decades. So originally, we always met with clients first, and it was immediately a question of judging their credibility and whether we felt they were being straightforward and whether they were relating the facts to us as best they could, and whether there was the elements of a case that could be made that was worth investigating. And you would then go ahead and retain them if you believed them and thought you could make a case, and you would spend several months investigating. In a medical malpractice case, that means obtaining all of the medical records related to their care and then hiring experts in the appropriate fields to review the files and then tell you whether they thought the standard of care had been breached in this particular case. Without a medical expert's opinion that there's something actionable, there's no point in going forward. Even in cases where people have suffered real harms, that's not always a cause of action deserving of a complaint for damages and the time and energy it takes on both sides to prosecute or defend. And plus, you're putting a client through, it's a very burdensome process for them. And I don't like to put people through that if it's not needed or warranted. And I'll be upfront with them. Now, nowadays, though, things have changed. We get so much information immediately. In personal injury cases, oftentimes people have phones and video cameras, and we'll have video on intake. And police reports within 3 or 4 days are available online in many cases. And so you'll have a lot more evidence, pictures of property damage if it's a motor vehicle accident, picture of the hazard in a slip and fall or premises case. Uh, you can get online copies of fire department reports and paramedics reports, and have an incredible amount of information at your fingertips, which allows us to make much more informed decisions very quickly. But the bottom line has remained the same. There has to be evidence that meets all of the elements necessary for whatever cause of action might exist in their case before we take that case.
But
Or
you try to
even
do that pretty quickly. You screen them fairly quickly. And the other thing
absolutely.
you pointed out again, as I say a lot of time, eminence is an expertise. You've just pointed out that just because somebody's an eminent whatever doctor doesn't mean they're actually expert in times of court, in terms of how to present. So eminence and expertise are two entirely different things. And as a lawyer, you get to know pretty quickly who can do what.
Oh, absolutely. And there are a number of medical experts who testify very well and obliterate their much more prestigious peers who attempt to testify but do such a poor job of it. Bedside manner is important outside the patient care relationship too. The ability to communicate with everybody, I think, does sort of carry over into trial. If the doctor is relatable and approachable and speaks to the jury, the good experts on either side always look at the jury, make eye contact, explain what they're saying in plain language. And some of the prestigious doctors come in and they're very eminent, and they're usually it's very intimidating when you're a younger lawyer to see a very prestigious doctor. But there are doctors who are not nearly as prestigious or well thought of in their profession who I'm much more concerned about when I know they're going to trial against me. And it's because they are very good at telling the story and explaining the medicine. And
Yeah, and they know what they're talking about. So let's finish with this one. What now would you have told your younger self? What have you learnt for all your years of practice? And a young person, maybe your children or somebody else coming in, what would you say to them before they took on this profession, and specifically the med malpractice or the personal injury? What would you tell your younger self, or your son coming in, your daughter coming in?
Well, I would tell them a number of things. I do tell people, like in California, especially, most attorneys get jobs after their first year of law school, and it's based entirely on grades. And one thing I really wished I had known was that the bar review course I took after my third year of law school is also excellent preparation for your first year of law school. So if you haven't gone yet, take a bar review course before you go to law school, and you'll already have all of the materials you need to get off to a flying start in law school, which gives you a leg up in the job search later, because you're likely to be in the top of your class that first year because you've come in prepared and already understanding a lot of the core concepts, whether it's in torts or property or family law or criminal procedure or civil procedure. All of those are covered in the bar review. The other thing I would say is have a fire in your belly about what you're doing. Care about it. It's important. Don't think about this as a job. If you think about litigation in particular, but I think any job, whether it's litigation or not, I've told my own children, pursue something you're passionate about, that you care deeply about, and don't worry about what everyone else thinks. If you find joy in it and satisfaction, then do it, but do it to the best of your ability. Clients are depending on us. This is their one case where they're in court. We have thousands of cases within our firm that we're handling, but each case is important. The most important thing in many of these instances for that person that they may ever confront. And you have to keep that in mind. You're not doing this for the job, the paycheck, the prestige. You're doing this because it matters to somebody, and they're counting on you to be their voice and to make sure that everybody who hears the story understands that it's important. And even if it seems unimportant to the insurance adjuster or defense counsel or the court, It does matter, and they deserve their day in court. We guarantee that in our system, whether you're in Australia or Canada or anywhere in the United States, everybody is guaranteed their day in court, and they should get it. And they should get it with people who care enough about their case to present it in a way that's understandable and follows the law and persuades people that we're right and that they get what's fair. And that if they've been injured, the people who caused the harm pay for the harm. You break it, you should buy it. That was the rule my parents taught me as a kid. I broke a window next door. I had to work all summer for the neighbor to pay
Pay the
that.
window. And
Yeah,
so the whole thing, it's not the process, it's the people. And I think
yeah,
you've summed that up beautifully. And all your way through, it's always been about the service to people. Does that pay you? Of course it pays you. And to say anything else that I'm not after, I want to be paid for my work. Of course you do. But you
yeah,
want to be paid for good work. And
yes,
that comes out of your passion for people and taking your knowledge and putting it into action and doing it for that person. As you say, this is that person's chance, their only chance, and
yeah.
you're there for them.
It's
Don, this
really
has
not
been
a,
wonderful, and
yeah,
I've been,
it's really
I
not
hope,
about us.
enlightening to all the people listening at the moment. I hope they've got some very, very good points out of this. I'm sure they have. And thank you so much for joining us today.
It was my pleasure, Professor. Thank you.